afternoon, everyone. A very warm welcome to all of you present here. It's an absolute pleasure to have you with us as we embark on this exciting conference on IBC together. I am CA Kavya Shah, an auditor by profession, a host by heart, with an inquisitive mind to learn and attend new things from great personalities. And I am honored to be your host for this session. So how's the conference progressing, friends? I'm not getting any response. How is it progressing? Okay. So yes, I am pretty sure that you have had insightful discussions in previous two sessions. So now this third session is about the zero-sum game, which means a situation where neither wealth is created nor destroyed. IBC aims at value maximization and protecting and preserving the value of corporate debtors while balancing interest of stakeholders. So, may I please request CA Abhinav Malavya, Managing Committee Member, to escort the speakers of this session. We have here with us CA M. Suresh Kumar from Coimbatore, who has been an IP in multiple IBC mandates, including Dharani Sugars, Hindustan Photo Films, Isam Rerol, spanning across diverse sectors. We also have with us CA Shailendra Ajmera sir from New Delhi, working as a partner in E&Y and leading the insolvency practice within restructuring and turnaround service line with professional experience of over more than 30 years. He has handled diverse sector resolutions including matters like Ruchi Soya, Go Airlines, Supertech ORB, and many other key resolutions. Let's give it up for CA Parveen Bansal sir, IP and registered valuer in SFA class and a versatile practitioner from New Delhi with more than 35 years of experience, of which he has been working in insolvency domain for the last 7 years. He has handled 25 insolvency matters and was a resolution professional for 2 Lenco Group companies and liquidator of Raman Ispat Private Limited. Last but not the least, let's have a huge round of applause for Secretary of Ahmedabad branch, CA Shunit Shah sir, our moderator of this session and a prominent insolvency professional with over more than 18 years of experience. He has managed claims of more than rupees 13,000 crores, comprising many insolvency corporate resolutions. He is currently also pursuing doctoral research on IBC 2016. So may I also request Abhinav sir to felicitate the guests. Okay. CA M. Suresh Kumar sir. Let's have a huge round of applause. CA Shailendra Ajmera sir. CA Parveen Bansal sir. Let's give it up for him. And CA Sunit Shah sir. I am sure your enriching knowledge session will make this event truly extraordinary. Thank you, sirs, for gracing the occasion. So without wasting much time, let's dive into this important event together. May I please request CA Sunit sir to proceed this session. Thank you, sir.
I welcome all the panelists here. First of all, thank you for joining. Thank you for accepting our invitation. Uh, I would say I am into insolvency practice, so I know the kind of matters they would have handled. Just handling a few crores of matter, I feel what difficulties that we are facing and the kind of matters that they have handled. I would really appreciate the panel that we are having right now, and all the members here, all the insolvency professionals will have a wide variety of experiences that they might be sharing. So our topic is about the zero-sum game. So when we were discussing about the zero-sum game, so it turned out to be whether it's a acceptable thing or not acceptable thing. What does zero-sum game means? So first of all, my first question to all the panelists, whether we can make everyone, every stakeholder, every corporate debtor, or every resolution applicant to be a winner in a zero-sum game or not. Sir, Pravinji, I'll start with you.
Hello. Yeah, my way of looking at the thing is, actually IBC is a zero-sum game. This is okay. No wealth is created, no wealth is destroyed. As soon as we put into that, there question comes in. What happens to the haircuts? Because every financial creditor is getting haircuts. Operation creditors are getting haircuts. Okay. They are losing their money. So why their wealth is not destroyed? The way I look at it, that when the IBC, once we go for the resolution, they are getting the haircut. Haircut is nothing, because what's the claim they are talking about it, that is nothing but a book value. And what they are getting is actually true value, because it's very well known. There is something we call it a credit risk. So when they have given the money, that means they had taken a credit risk. And what money, the claim which they are talking about, purely and purely book value, and true value gets discovered through this process. This is my way of looking at things.
Shailendra Ajmeraj.
Thanks. Thank you. So I think before we get into that, it's extremely important as an RP as to we really understand who the stakeholders are and where they are coming from. So you would have members in the committee of creditors who are actually driving the process via the RP. You would have variety of creditors, including the people who are the important raw material suppliers, your debtors, your any other capital providers. Then you have the employees who are the most important people. So I think while the zero-sum game, at the end of it, there are, all of it depends really on what the outcome of the insolvency process is, what is the value which has been given. But I think the law envisages enough and more for everyone in protecting the rights, which I will not go into details, but there is everything to be done such that the rights of each of these different stakeholders are protected. Is that really happening? That is really the construct of what the resolution plan looks like. It's not same for everyone, but definitely from a softer perspective, the continuation of CIRP and culminating into a appropriate resolution plan is critically very, very important for a lot of lives, including the employees, the continuity, the taxpayers' money. If the entity survives, the exchequer earns. So there is a lot of it, but I would say that at the end of it, it is really what is the construct of the resolution plan which comes in and how valuable that is.
Hi, good afternoon. In my opinion, it will be like in a macroeconomic perspective, if you see, this is a positive sum game. But if you get into a microeconomic perspective, obviously you will have a negative thing. So if you see how it is a positive sum economy as a whole, see for example, I have data in Tamil Nadu where I come from. About 16% of the industries are closed prior to IBC. That's the statistic. So to that extent, about 16% of the capital invested in various industries was lying idle for an economy like India with a growing population, when you have so much of idle capital invested or not productive, it's a big loss for the country as a whole. In a macroeconomic perspective, this IBC has turned it. Majority of the assets are brought back to production. Maybe the owners have changed. Now the asset is productive. You don't want to invest a big capex to bring it. So it generated a huge set of employment in that way. So in a macroeconomics perspective, certainly it's a positive sum game because lost is already long back lost. So now whatever is gained is just a positive impact. But when it comes to when micro level, obviously there are a lot of stakeholders, as mentioned by the panel speakers. There's many people are losing the money. Obviously, finally the liquidation value is realized. What best is that only the liquidation value possible. But in CIRP, there is a better probability, but in liquidation it is less. But on an overall basis, in my opinion, it's a positive sum game. The IBC has contributed for the economy as a whole.
Thank you, sir. So I think so all the three panelists do believe that IBC is a zero-sum game. So I think so all there might be certain confusions as to decide or to conclude on the same, whether it is a zero-sum game or not.
Can I add?
Yes, sir.
Okay, I just wanted to add a little more. Actually, the IBC process is designed in such a way that it defines the true value for all of the stakeholders. I just wanted to make a little bit more clarity. From the creditor side, basically, they are getting what is the right true value. Actually, the value starts from the value of the assets. Because it is put through the competitive process. So that's why the true value of the assets is getting discovered through the registration process. That's the first thing I want to tell. So that, when it comes to that true value is discovered, that true value amount is getting distributed among all the stakeholders. So that means basically what they are getting is what is really due to them. It is not, see, one way to looking at it, that their value, I would say the values for all the stakeholders gets reset and get paid for. That is the way I put it up. That is why I say it's a zero-sum game.
Thank you, sir. So we conclude that for now, time being, we conclude that IBC is a zero-sum game. We can discuss at length after this session or later on. We can have some views from every panelist present here or any insolvency professional, because it's a complicated tagline that we have given, that is a zero-sum game. So everyone is open to discussion post this session. Yes, sir. So I'll be starting with Suresh Kumarji. Sir, you have handled various matters, complex matters that I have seen in your profile, right? And I would like you to discuss about the practical difficulties that you would have faced. Mainly focusing on the practical difficulties as a IP you would have faced and the way you would have sorted it out so that the process becomes smooth and final resolution plan came to place and got approved.
As previous speakers have said, the first initial 7 years, many of the backlog matters only all of us have taken up. So if you would have get many of the assignments where the enterprise is closed for 10 years, 15 years, 20 years. We have handled, say for example, a public sector undertaking called Hindustan Photo Films based out of Ooty. The debt claim is about 50,000 crores. The company is not operating for almost 10 years, and for 25 years it was not in track. In the sense, 1995 itself the company was sick. But it was prolonged up to 2015, just dragging, only interest mounted, employee issue mounted. Government was not able to come out of it. Finally, although they went to BAFR, they were not able to come out of the entire thing. At last, the insolvency came as a way out for government to get rid of that company. Honestly speaking, government never gave insolvency in any of the matters. They always tried to settle employee, tried to settle all the bankers and all. This is one such case. Government want to get rid of it. Because so much of trouble, government was not able to solve it. Even today, there are a lot of employee cases are there. So this insolvency came as a boon for them. But still, I have, although one part of the assets, we tried to resolve it through a resolution plan. 2 resolution plans, we cleared it off. One part of the thing came as a liquidation. So 2 demergers happened, and luckily Samir Kakar sir was here. He was the person sitting in Chennai bench, passed that first order where resolution plan approved, simultaneously liquidation also he is ordered that. So still state government issues are there where that liquidation as such we will be resolving it off. So that one, we are sitting with all historical problems where BAFR cases, many such cases have come up in the initial this 6-7 years of phase. We are trying to resolve it off. On the other side, for the running cases, the biggest challenge comes from the existing management and the loyal employees to the existing management. So when we take over, it is a difficult phase, initial 3 months, where we have to transit, because if we totally disturb it, everybody just lifts their hand and they are putting us in a bigger problem. And we are not experts. We are just chartered accountant having a wider area of knowledge. We are not in depth into any of these sectors. So although we engage experts to do that off, but the support of the existing employees became a crucial. I had a challenge in one of the 5-star hotel when we took over that. It doesn't have a GM. So I was about to recruit a GM. I had a threat from this thing. How can a new GM enter my hotel? I will break his leg. That's what the threat the original promoter was causing in the thing. So we had to sit there inside hotel for almost 15 to 30 days and stabilize the thing. But later on, everything went smooth. But the ongoing enterprise, getting the cooperation of the existing employee. We can manage the promoter legally and all, but getting the cooperation of the management is a big, the employees is a big headache, and we have to manage it out somehow and come out of it. These are some challenges which we've come across in that.
Thank you so much, sir. So now coming to Shailendra ji. So I was just about to ask this question at last, but so much of curiosity even I have, and all the resolution professionals might be having. So he being the appointed resolution professional of Go Airways. So sir, in relation to Go Airways, what do you feel like being a unique industry? Airline industries, I think so after Jet Airways, this will be the second matter that have jumped into the insolvency. So I would like first you to discuss broadly on the Go Airways insolvency that you are handling right now.
Thanks. The question is posed to me less than 12, maybe 15, 18 hours after the High Court has actually come up with a very stringent order on Go Air, which maybe most of you have read in the papers today or you will read later in the day. Having said that, I agree with my friend. When about a year back, I went into Go Air, my only experience in the airline was actually going for work or holiday. But having said that, airline is a very different industry. It's not a manufacturing industry. It's a very people-oriented industry. But more than that, it is also very regulated. By regulated, I mean there is a DGCA, there is airworthiness of a flight. You're actually dealing with something which is safety is the paramount. Little did I realize that there are very important stakeholders, which could be the aircraft itself, the mainframe, which is Airbus or Boeing. Then there is an engine which is separate to the mainframe, which could be which could be Pratt & Whitney, it could be CFM. Then there is a regulator, there's a ground staff. Now the fact of the matter is that if you're working on if you're at a very high speed, even a small rivet can actually put you out of order. In the airline industry, that really happens. If there is one of the stakeholders which goes a little topsy-turvy, the entire thing comes into a grinding halt. In this particular case, Go Air, the basic issue was that the engines which were supporting the A320 aircrafts which they fly were not able to repair them and provide them with the spare engines on a timely basis. That combined with COVID actually had a cascading effect on the performance of the company, where they were not able to pay. But when we took up the airline, obviously most of the aircrafts were grounded, AOGs, which is called aircraft on ground. But more importantly, Once you want to start the airline, you have to get all the necessary approvals from the regulator, primarily from the safety standpoint of view, before you start. So we were able to get that, but eventually you require a huge amount of capital, a huge amount of funds before you can start the airline. So in all aspects, I can sort of go on and on, but just want to suffice that it is a very interesting industry to work in, not many players. And also you can imagine the government's anxiety not to get into a duopoly situation. You can't have two airlines running. You need to have more than 3, 4. And Jet Airways is not the only one. There was Kingfisher before that. There is some other airline which is under similar issues, which you keep reading. So it's also regulated. It's also looked at it very, very carefully by the government, because they don't want the airfares to go up. They can't control the airfares, but if there are lesser number of flights, airfares will go up. The passenger load is just sort of exploded. There is a load factor of closer to 90%. So all of that put together, it becomes very important for the economy of India as well. So that is also another matter which you have to take care of. But more than anything else, I think the engine supplier, the mainframe supplier, the regulator are to be handled very differently than when we are handling a very normal manufacturing industry. So I'll stop there, but I can certainly take questions offline if there are some people who want to ask that. But it's a very long.
Sir, in continuation to this question, just the moment the Go Airways went into insolvency, so I was tracking the matter. So next day, I'm reading the newspaper that RP of Go Airways has decided to either take it as a going concern forward, or RP is deciding to have a settlement of this matter, so that, in fact, RP was trying to take this company back onto the tracks rather than alike the Jet Airways, which has stopped this operation. So this was the big news that was coming in the entire social media, that you were trying to get this company back on the track, that Go Airways will keep on running, though it is into the insolvency. So whether that has taken place, or how you are considering it as a going concern?
No, certainly. So if you take any corporate debtor as in an RP case, the first and foremost understanding is that it's going to be on a going concern basis. So that's absolutely taken. What we needed to get the company going was funds, obviously, and the regulatory approval. During that period, regulatory approval was sought and was given. Funds were arranged, but then there was a huge question, and this is something which, if you guys go and read the newspapers today, I may just take 2 or 3 minutes as an important aspect. There's something called a Cape Town Convention, wherein India is signatory to Cape Town Convention, which says that if there is any default on part of the airline, the lessors, as you all know, that these are typically sale and leaseback kind of an arrangements where the promoter will go and order a huge amount of aircrafts with Airbus and with Boeing, as the case may be. And then there are lessors who come in, they basically sell it and lease it back. So it was to protect the lessors to get the aircrafts out on town, I think, out of the country. There were a lot of instances in many parts of the world where they were not able to take the aircrafts out. So India is a signatory, and the lessors always believe that since India is a signatory, and if there is a default, they will be able to go to the regulator and get the planes deregistered from the Indian perspective and take them away. And their faith was coming from the fact that in case of Kingfisher and Jet, all the planes could actually go out. But little they realized that most of the planes in Kingfisher were not sale and lease back. They were actually on the books of the company. So they could have done that. They were not lessors. But once this was tested, they figured out that this Cape Town Convention did not have the parliamentary approval, right? So then they got stuck, and the NCLT said that there is a moratorium once the company goes into IBC, and you can't take the planes away. The moratorium covers the airplanes. Once NCLT directed that as the law is, the lessors chose to go to the High Court. High Court, though it took a lot of time, it has now come up yesterday with the judgment that lessors can actually take away the aircrafts, and it has directed the regulator to deregister the plane. Having said that, when the government also realized this, on 4th of October, they came up with a notification that the moratorium for the purposes of the aircrafts and for the purposes of engines and the aircraft parts does not apply to aviation industry. in a normal scenario, there will be a moratorium. You can't touch. I mean, none of the financiers can take the machines away, etc., etc. But in this particular case, they have made an exception, which is a very big modification, and that modification roots out of the Cape Town Convention. But then the question was whether it was prospectively to apply, retrospectively to apply, but never said. All of that is behind now. High Court now has come in and said that the moratorium does not apply and has instructed the RP to make sure that the lessors can take away the aircrafts. Now, what is going to be the future legal strategy? That's too early to say, but just to tell you that this was a very different thing as far as the industry was concerned, and we were definitely going to be starting the airline.
Correct, sir. So when you talk about the moratoriums, Section 14 will not be applicable in these matters. So again, few questions are arising, but I think so we'll get back to you again.
Yeah. So just to sum it up, that notification is a very small notification, and this is precisely only for the assets which actually talks about in the notification.
Okay.
It's not to be widely used.
Paranji, you have handled Raman Ispat, that was a landmark judgment which led to PGVNL matter, and also which was, I would say, the kid of Rainbow Papers judgment which was going on through all these times. So which was a controversial judgment, I would say, and still pending with the Supreme Courts, I would say. There's no clarity about the same. So what about, how can you link this Raman Ispat, PGVNL and the Rainbow Papers judgment? Because I don't want a longer discussion on it, because if we go into the depth, I think so it will require a day to discuss. So quickly you can just give the insights of the same.
Yeah, I will just take you that how it has emerged. First thing, when the matter came in, that the PVNL, whatsoever PVNL dues were there, they had already issued the attachment order. They have already issued the auction notice. When I came in, I just run as a RP, and as a liquidator when I came, then I realized that I cannot sell the assets until the attachment is not over, because I have to go approach the NCLT saying that they have to remove the attachment order, otherwise it will be very difficult for me to sell. So taken that as a base, I approached to NCLT saying it is a part of my liquidation estate, so you please pass the order, and accordingly I got the order passed. From there they moved to the NCLT. NCLT rejected their appeal. Then they approached to the Supreme Court. Now when they moved to Supreme Court, they have taken another point, saying we are the secured assets. First they talked about, because they are talking about attachment, saying it is our asset and we can sell it. Then when they approached the Supreme Court, they have taken it that we have got a first charge. Because in the electricity code, they have got a provision where it says that for any outstanding, there will be a first charge created. That's which we call it statutory charge. Okay. Now, just to give you a little more idea about line of arguments, which become very important, because in the NCLT, they were taking the line of argument, saying it that they talked about the Electricity Act. They said the Electricity Act is a central act, Insolvency is a central act, but the Electricity is a specialized act, Insolvency is a general act. Hence, Electricity Act will prevail. Hence, the asset is mine. So it goes out of the IBC. That is the line of the argument they had taken, which I always said, no, it is not possible. My argument was that both are the acts, special acts. Insolvency Act came later, so it will prevail automatically. So this is the way I have countered the first part of it, the attachment side of it. The second side came in, whether it's a secured asset or not. See, because it is a statutory charge is created, because there is a specific clause is there. So they have come out very clearly that the charge gets created. That is the way stand I have taken. I accepted that stand, because in fact in the Supreme Court we had taken an argument saying this is a government dues, just to make sure that it comes out. It should be down. There the Supreme Court has clarified that made a distinction that it is an operational creditor. First point, they have made it very clear. These are not the government dues, because whatsoever the dues are there, that is on account of the electricity supply, and anybody can come in and supply the electricity. That is why they are operation creditor. So first point out of learning is that the distinction has to be made, what is the central government, what is the government dues versus what are the operation character dues. That is one distinction is very clear. The second point is very clear, that whatsoever charge is, once it is the statutory charge is there, charge gets created. Frankly, in Rainbow also, it is the same thing. They have said that charge gets created once the provision is there. In the Gujarat VAT Act, there is a similar provision is there. So that is what they have taken a stand. Okay. But the distinction has to be made, because when the Raman Ispat came in, they made a comment that there is a gap in the Rainbow judgment, because once it's a government dues, because in the Gujarat it is a state government dues are there, and once there is a specific clause is there, because then they talk about the section 53. In the section 53, there is a separate clause is there, central government dues and the state government dues. So it should fall into that. That is what they have came with the comment. Based on that particular comment observation, the review petition application was filed, and review application was basically rejected, not based on the merits, but on the basis of maintainability. So up to here, I think I'm just making the points clear. Now the question comes in, what is the position as of now? The way I look at it, that if dues are there of the operational creditor, statutory charge is there, then it becomes a secured creditor, and that is the stand I have taken. That's the first point. Second, I want to make it. The second point is there. See, if you see this, there are certain laws are there. I'm just coming from now, I will just explain to you practically also. I have handled another matter also, this issue. Then comes the central government dues. If you see there, the laws which are there prevailing as of now, like GST Act, Income Tax Act. In GST Act, you will find that they talk about the first charge, then they give an exception. So essentially would mean that the GST, if any GST dues are there is no charge gets created when it comes to insolvency side of it. So similarly, in the Income Tax Act, you will not find this thing, frankly. But when you see the state VAT side of it, there are a lot of laws, state laws, where you find this kind of laws. So the way I look at it, that if there are government dues are there, and if that particular clause is there, the statutory charge, if there is statutory charge clause is there, then that has to be respected, and that will move to the secured creditor. If there is no such clauses there, that means it has to fall into central state government dues. So I think I have clarified how to make a distinction out of it. Practically, I'll just give you another thing, because this particular issue I faced in one of my matter in Lanco Solar Energy. I have basically submitted the registration plan for the approval, and the issue came in that how to apply the Rainbow judgment. So I'm just giving you a practical side of it. There, what we did, we went by one all the claims. First, we went to the income tax. Then we said, okay, no charge is created, so Rainbow judgment doesn't apply. The second thing we talked about the VAT claim. In VAT claim, we divided into two parts. One is what is the state VAT, what is the central VAT. When we go to central VAT, no charges, no such clause is there, so that is out. Then we went to the state VAT, then it was a very small amount. So what we proposed to the bench is that, okay, we are requesting the SRA to deposit that amount, pay it to that amount, so that gets cleared. And once we paid it, then Rainbow judgment matter gets sorted out, and my registration plan got approved by the NCLT. I hope I clarified everything.
Thank you, sir. Sureshi, so just when we are talking about zero-sum game, so any specific clauses in the resolution plans that you would have as a IP found it out, which are specifically targeting the balance of the security interest or balancing of the interest of the stakeholders, where we can correlate with the zero-sum game. So any specific points you as a IP has come across in the resolution plans submitted by the PRAs?
In the resolution plan, I have 2 points to say it of, especially when it comes to an operating asset, the value they give it for the operational creditors is a key thing. Many times resolution applicant feels that they are not having any charge, nothing payable to them. That issue is coming up. But in Chennai, NCLT and all, if they don't offer anything to operational creditor, the judge himself not approves the plan. So there were situations he returned to the plan, go speak with them, make some arrangement for operational creditor and come back. So the bench is also now very conscious about making something, even though their residual realization is nil, they are insisting to do it in an ongoing enterprise matters. So that any resolution applicant who comes forward should try to address something for all the government dues portion also and all other operational creditor, whatever it is. Maybe it may not be big amount, but at least a small portion of it, maybe in a gradual settlement kind of thing, can be that one thing we can get. And second point, when the initial plan comes up, we always see that there is some, the kind of monitoring committee after the plan is approved, how that will be implementation will be completed and how it will be taken forward. The initial plan, when it comes, it is poorly planned. That maybe only after 1 or 2 rounds of iterations, they make it clear. Otherwise, there is a lack of clarity in how the plan will be implemented. They all think that money coming will solve the problem. No, that's not the case. How that will be dealt with. There was a problem of the PAN number. One of the plan, they said, we want the PAN number to be changed, we want the unique identification, means the SIN number to be changed. He gave a clear-cut reason. PAN number, government will not change it off. But he came up with the specific prayer. We are waiting for the courts to order on that matter. He gave a clear reason of it. So even you are drafting the plan, the implementation leg also has to be seen. And as a resolution professional, we also should discuss with the plan applicant with the COC and see that the prayers, whatever they take, sometimes they may draft some 40 pages prayers, which is, many will not be even attended to by the court. So logical things we have to consider it and we have to weigh that off. That we have to focus on that.
Shailendraji, now what about, sir, do you feel that increasing the competition between the potential resolution applicants will lead to the balancing of the security interest in any case, or it will not make much of sense, or we will be looking out for the best PRA, maybe 1, 2 or 3 they are coming rather than 30s and getting the resolutions at a faster pace. So do you think that more of the competition between SRAs will lead to the balancing or it will delay the process further?
Yeah, so one underlying thing is always commercial. Most of the guys who are taking the decision are financial creditors, who are typically the banks. In a way, if you are able to successfully get 2 PRAs or 2 or 3 PRAs to compete, the value goes up, and the COC committee members are, like he said, are very conscious about the fact that there has to be some amounts which are given to operational creditors and the other stakeholders, including home buyers in some particular case, etc., etc. So having a healthy competition definitely helps, but I don't think that is really the way in which the committee of creditors or the PRAs look at it. It's at the end of it more commercial, and that's the most practical answer I can give you. But obviously, if the amount increases and if the financial creditors are getting all the amount, then under the waterfall, other people will also get it. But does anyone attack it from the perspective of making it more equitable? Answer is really no. It's more commercial, even at this point in time. But yes, when it comes in, we obviously give a softer nudge to the PRAs to ensure that there is something for everyone, such that the courts, like what you said in Chennai, similarly in other places also, judges, first thing they look at is what is being opted for the operational creditors. So that now I think the PRAs have become smart enough. But is that a justification as to how you deal with it? Answer is no, not yet.
As a RP, I think so we should not promote the competition, or we should not try to run after the PRAs to get more and more PRAs. This is what I think, so we can conclude.
No, that's not what I said. I mean, maximization of the value for the corporate debtor is obviously the RP's task, and we will do whatever it is for the purpose of increasing the value. But increasing the value, does it lead to percolation into the different stakeholders is not the reality. I mean, it could still go, everything could still go to the financial creditor.
Understood. Sir, Parveenji, again coming to like the airline sectors, what Shailendraji has handled. I think so you would have handled many more matters for the thermal industries as well, which I have gone through. So, sir, power industries. So again, that is a complicated insolvency resolution that anyone can handle. So I just wish you convey to everyone how this process runs and what are the intricacies involved
Okay.
into this kind of insolvency.
Yeah, basically, I always divide our process into two parts. One is the management side of it. The second is the resolution side of it. So when we talk about the industry specific, we are talking more about the management side of it than of the resolution side of it. Okay. First thing. The second thing, when I talk about my experience, I have handled the two companies of the Lenco group. One company of Lenco Thermal, second is Lenco Solar Energy Private Limited. When you talk about the one, unique thing about, of course, is the power industries. In my case, both were the holding companies. So what a holding company means, it will have around 20, 22, or 20 to 25 downstream companies. So that is the one challenge I have faced. Basically, in Lenco Thermal, if you really see, that company has got a very small hydropower plant, and everything else is reflecting as an investment, including all the thermal plants. That is a very large thermal plant, frankly. So when you talk about handling the industry, so because it is a small hydro plant, so I will tell you the issues which come in the hydro plant. Hydro plant is such a plant that it will run automatically. You don't require to do anything. Only two challenges come into play. One is the local contractors. Because this business, because the plants are, will be somewhere in far remote area, and the local contractor would be very powerful. So you have to handle it very carefully that the labor remain deployed, issues gets addressed as fast as possible. Because in one of my issues which I came in, that the transmission line got snapped at some place. So it is a difficult hilly area, so we had to ensure that the labor is deployed very fast and the issue get resolved, otherwise it is a risk to the human being. And it can get any type of problem. So that is about the hydro plant. Okay. Then comes the other side of it, the Lenco Solar Energy. That is basically the main company is EPC company. EPC for the solar plants. It is a EPC company and O&M, both things are handling. Then the uniqueness of it is basically which is more similar to the other EPC companies which come into play. There are so many sites are there which are running across India. Then of course first issue was the security, because it's a long area. So everywhere the huge manpower is there, and we have to ensure that security remains deployed across, and that too within the framework of the insolvency. Because one of the challenges you faced is that security people wanted the payment immediately. And we cannot pay the past dues. So what we made it sure that we told to them that, look, you have to file a claim for the past dues, but at the same time, what we did, that the credit period, otherwise you were taking 3 months, we reduced to 1 month only, so that they get the money and they can churn the money and they can run the money. So that is the one way we have sorted out the issue. The second issue which was coming in was accident has happened. There was a fire, so the whole of the plant got destroyed. So customer came in because he said, you please immediately, you have to start it. And as a RP, we have to make sure that customer gets serviced. So then accordingly, what we did, we deployed the money. We taken out the money, we deployed the money, and we made sure that plant is put into place, and the insurance claim money will come thereafter. That is second challenge in the CPC industry, you got it. Of course, third issue is coming that we don't get any new contract. So what does it mean? It translates into the problem that we have to do the resolution as fast as possible, Because once litigation goes on, and the value of the all of the matter, comes down day by day, because the contracts which we are having, they were expiring, and the underlying value of in EPC company is the contract validity. These are the few things which I can explain.
Agreed, sir. Shailendra ji, again coming back to one of your landmark case that you handled, that is Ruchi Soya. Again, Baba Ramdev would have taken it. So just wish you, if you can discuss with everyone again about the Ruchi Soya intricacies and all, any specific matters that you would have come across in this insolvency process. And yes, again, going back to the subject that whether you feel that Ruchi Soya insolvency and the resolution plan, approval of the resolution plan would have actually lead to zero-sum game, or it would have not, it would have actually resulted into the wealth creation.
Yeah, so very quickly, the Ruchi Soya was close to about $2 billion outstanding when we took it. It's a long time ago. It was one of the first few 25 cases. It's been resolved for now 4 or 5 years now. We eventually got to about a 50 cents to a dollar, 50% recovery. But little did I when we went in, there was a cash of about 40 odd crores. When we got out, the cash was about 500 crores as cash and cash equivalent. What I realized in that period is that if you keep all the problems aside, there was no problem as far as the operating company was concerned. Ruchi Soya, as you know, is one of the largest edible oil companies, farm to fork, largely on the palm oil, sarson, and other ingredients. So the reason I said is that the money went manifold was that if you were to keep a creditor's issue on the side, operating-wise, there was no issue. So much so that we were dealing with so many of farmers because most of this soya was procured locally in Indore and around that belt. I still remember the first meeting where we were telling them to file their claims, etc., and there were like hundreds and 200s of people sitting there. They had no clue as to what is to be done. Then we made additional effort to make sure that we were helping them. So much so that after 2 or 3 months, when the payments started getting regular, they were wondering whether the RP and the RP team could run the company forever, right? Similarly were all these CPO providers from Malaysia, Indonesia, etc., because they started getting comfortable with the process. Like sir also said, we also had an issue where these guys had given raw material 1 week before the company went into liquidation. Now you can't go and explain it to them as to, now you have to file an application. We went to the court said not going to say anything because court says that, the law says that if it's a liability as on the day on the ICD, you cannot pay it. But again, we chose a different matter. We took it upon ourselves that we were actually paying them and doing some teaming and lading so that their cash flow is not getting affected. Similarly, employees, none of the employees left. We started paying salaries on time. Resolution plan was a very interesting phase. There was Adani, there was Baba Ramdev. Eventually, there was a very cordial competition between the two, and eventually Baba Ramdev took it. But little did I realize that, if all the problems are kept on side, we ran that company for about 1.5 years, and there was not even a single day when any plant was sort of shut down for the ask of money, etc. In fact, we actually went up from rupees 50 crores to 500 crores, which was kitty which went to the banks. So at the end of it, if to answer your last point, that if you balance the whole perspective out, at the end of it, everyone is a winner over there. There's no additional money which is going to anyone, but there is equitable distribution for everyone.
Okay, so it's actually an inspirational story for all the resolution professionals, the way you have run. So when you talked about the teaming and leading part, so I think so there might be the chances that you are paying off the dues which are outstanding before the CIP period as well.
It's not
CIP date as well.
It's not so much about maths, as sir also said. It's about just making sure that the continuity of the production is not getting affected. You are actually we started giving them some of them advances because, frankly speaking, cash was not an issue for us. But we went to the court, we went to the IBBI. They said do whatever you can, and we stuck our neck out to make sure that the value of the asset was actually improving rather than, because at the end of it, I cannot be taken to cleaners if I've done something by which the value of the asset has gone up. And imagine a situation where there was a production loss, or if you were not getting any production out of it because raw material was not available. So at the end of it, it was a win-win situation. So it's very difficult to put in whether I did not follow the law, but at the end of it, they were happy in providing the raw material.
Yeah, but let me add something to this, because teaming leading is one of the methods which you used it. But of course, the issue comes in the pre-CRP claim what to do. Of course, one point is that one issue which you challenge it, that guy will say that I will not provide your service. Then I have to speak to him directly and make sure, tell him that what is the advantage you are getting once you continue with us. That is the one point. I always say that your money is secured. Before the CRP, money was not secured. Today, money is secured. Why you are losing the business? That is the one point I have used it with my security guys and told to them, please work, continue to provide the service. Rather, you were taking a risk before the CRP. After the CRP, you don't have any risk, and they continued. That's the first point. Second point which I have handled it, the pre-CRP, team leading had helped me to continue to make sure that cash flow doesn't affect. The second thing which I had done it, I had discussed with this registration applicant very clearly, saying it that since it's a people business, plus remember one thing, the business is because it's a labor business which is controlled by the local mafias. So you have to continue to provide the service. So after the registration plan has come in, you have to keep a provision of money to settle out their old dues. So which he has kept it, what's so critical were there, he kept the money, he settled it thereafter, and the matter was sorted out, business was running.
Yeah, to keep the company going concern, or to have this wealth creation, that company doesn't fall into like a shutdown company. I think so such matters, such decisions have to be taken looking at the situations, and obviously not going against the law. This is what I say. Again, there's a paucity of time. So sir, quickly, Suresh, it will be like a fire chat kind of a thing. So yes, no, and a one-liner kind of a thing, if you can say, that whether CRP and the liquidation process that will be going on will result actually into a zero-sum game, yes or not, and along with the one or two liners that you can say.
Yes, it can result in a zero-sum game, provided the time factor is dealt with correctly. See, time is the essence of it. So if the CARP resolution and all happens on time, and the judicial system, everything cooperates with that, certainly it will be zero-sum, and it can have a positive impact also. So time is the essence in the whole process.
Shailendra ji.
No, I completely agree. That is the whole spirit of the law. But I still believe that while zero-sum is there, but at the end of it, it's the construct of the resolution plan which comes in.
Sir.
You want to know? I think I'll take 2 minutes more. See, in whole of the resolution plan, when you talk about the zero-sum game, the creditors becomes the most critical component of it in whole of the game, because that is where the actual balancing of interest is required. I'll just share with you few tips how to handle it. I have handled practically. First, I would always say that the classification of the asset, the creditor has to be perfect. That's the first thing. Admitted amount has to be the correct. Then this is the first step, but there are other steps also, which I would like to say quickly, because as I said, the next issue comes in the book liabilities. I will give you a practical example which I have handled it, the book liabilities. There was a claim of the workers. Till the registration plan, till the approval of the registration plan, they did not submit any claim. So what I have handled is, I have kept a provision for that payment. After the approval of the registration plan, I invited the claims and made sure that all the claims get settled, so the new SRA doesn't get a problem from the workers. That is what I want to tell you about the book liability side of it. Then there are problems comes in regarding the contingent liabilities. See, there are a lot. You see, what I wanted to say is, see, whatsoever there would be certain payments, for which there is no claim and there would be unforeseen claims are there. That possibility is also there. In one of my resolution plan, I have handled it, saying it, you make it a provision for some amount. We will wait for 1 year time. If any claim comes in, then we will make sure that it get paid for. And ultimately, happened that PF department submitted their claim. We settled it down out of that particular amount. And that is the way SR did not get any extra liability. So this is all I want to say about it.
So for now, we conclude it like this, that it will zero-sum game, as we are discussing. It will not create new wealth, or it will not destroy the wealth of the corporate debtor that is already into existence. This is what we can conclude. So quickly, two questions we'll be taking quickly, and then we'll wrap up the session.
So in that case, this kind of piecemeal resolution plan are allowed or not?
Yeah, so it all depends on how the resolution plan is worded. Debtors recovery is one. I've worked on a situation where there was a pass-through which was meant for the creditors. Similarly, you have to look at it from a when you have these preferential transactions and all the other avoidance transactions. Again, there are documentation which you can do in your resolution plan where at a subsequent date, if these amounts are recovered, they can be passed on to the creditors. So it all depends as to how you sort of word it in the resolution plan. It's possible.
Thank you.
Sir, on practical aspects too, because you all learned panelists, keeping aside whether it is a rainbow case or Raman Ispat case, assuming that department still want to go and pursue the litigations, being a secured creditors, although it is not going to impact on the SRA, because whatever money he has to give, he already paid. It's only changed the chronology or hierarchy or the payments. Now, if anything, any notice is to be given, or the department has still issued any notice for the any past being taken, and assuming this is a secured creditor part, who is going to impact? To whom the notice will be issued? Whether it is to SRA or a CD, whether the RP or COC, ultimately who is going to impact with this? How this practical problem is to be actually attacked?
Okay, I'll just add you, because the question is that after the resolution plan has been approved by adjudicating authority and the process in implementation is closed, notice by the department will be issued to whom? One point which I would just make you point, that corporate debtor remains alive before and after. So that means all notices, everything will come to the corporate debtor only, point number one. Point number two comes in, who will handle it? Okay, this ultimately has to be handled by the SRA with the help of the monitoring professional till the monitoring committee is there, and thereafter by the SRA himself. Okay, let me tell you, many times I say about it, the insolvency asset. I always tell to my clients, the investors, very clearly, when you go to the insolvency, we are handling the distress asset. You can have the near clean assets. You cannot have a very clean asset. Only thing why I have said so near clean asset means, that means ultimately you will be the winner in the matter, but you have to incur the litigation cost. That is why you are getting very high margin. Otherwise, in normal situation, you get X margin. Here you are going to get 3X margin. So that means you have to be ready to bear the litigation cost. So what you are saying is, what I want you to say, I think you are clear about it, what I say about it.
Sir, if the litigation still needs to be appealed, where to appeal? Whether it is under VAT Act or the state law or NCLT or NCLT?
Answer is very simple. It is the NCLT who has got a jurisdiction. Not if you go to a department, you will not get remedy, rather you will complicate the issue. Because here you have to fight the case from the IBC perspective, not from the income tax perspective. So I hope that makes the point clear.
Thank you, sir.
Thank you, sir. So may I request Abhinav Malavia, sir, to propose vote of thanks.
So, on behalf of Ahmedabad branch, ICAI, I propose this hearty vote of thanks to all the learned speakers. It was a learning experience. I think it would have been a learning curve for all the participants, hearing the experience and the practical approach adopted by the moderator and the knowledge deliberation by all the speakers. So thank you so much once again for your nice knowledge deliberation and presence at this Ahmedabad branch dais. We'll be eager to welcome all the learned speakers once again to Ahmedabad branch. So thank you so much, sir.